Yeah, good morning, everyone. I believe that the one of the chairs of the session, and now every chair of the session is here. So we're all good. Um, Please do not use your AI note takers for the sake of it if you don't wish to attend the meeting. I mean, it is beyond pathetic now. I mean, if you wish to attend, you can just mute yourself. You can add your comments in the chat, but sending your AI and not coming up, that is something which we really have to now. Just because everyone is doing it, this is just beyond pathetic. So I'm so sorry I have to say this, but I have to say this. So whosoever has this Fireflies note taker, I don't know. We're gonna remove it. Yeah, but hi Kailash, hi Ayush. I think we should start in 5 minutes. Let's wait for a little bit more
Sure.
for people. Yeah, yeah,
Yeah, sure.
That's fine. We can wait for 5 more minutes. So,
yeah. 5 more minutes and then we'll go ahead anyhow. Yeah, yeah. Yeah, I'll open my camera in a minute. But yeah, of course, if anyone wishes to share the link to the session to others who wish to come, please feel free to do so. Of course, there will be attendees, so that will be another thing. But yeah, then we'll add one by one if people have any questions or things to add. So we'll be happy to do that. But feel free to share it to people or friends. Yeah. Yeah. Also, I think I remember that Bogdan might be joining as well. So that's a good news. He'll add a lot to this discussion. Um, that's there. So I think what we can do is maybe Kailash, since you have a presentation to begin with, which is good, uh, a good idea. We will start in a few minutes with first your presentation, then we'll open the floor after
Sure.
the co-chair also has something to add, which I hope he should have, and I would really appreciate that. But anyways, um,
Hope the screen is clearly visible.
yeah. You can even put it on full screen mode, like the presentation mode,
Okay.
since it's PowerPoint. Yeah.
Sure, sure.
I can see it. I can see it.
Okay.
Okay, we'll start in 2 minutes. Anyhow.
Sure.
All right, so we begin the session without any further delay. I tried my best to wait for people. I think they'll join in the process itself. So that's perfectly fine.
So shall we
So
start?
yeah, let me
Okay.
just quickly introduce the purpose of the session and then.
Sure.
Um, Hi everyone. My name is Abhivardhan, the founder and president of the Indian Society of AI and Law. Today we are here for an interesting session because we are going to discuss, for the sake of feedback, on the draft guidelines on the examination of computer-related inventions by the Indian Patent Office. The deadline to submit the feedback is 15th of April, if I'm right. So we have technically a week or 10 days to submit the feedback. But through this one session, as a matter of fact, we are trying to gather feedback and pointers to see how exactly people can contribute. We will be allowing cameras for attendees. We'll be allowing mics for attendees, so keep yourself muted. And whenever you wish to speak, you can add up accordingly, waiting for the stakeholders, that is the two chairs. And I will be more of a spectator in the session. Uh, so that will be an approach, but I think it would be great if you wish to add anything. So that's it from my end. Now I'll pass the baton to, first of all, introducing the two chairs. We have actually, this is a joint committee session. Kailash is the chair of the AI Development Committee, which handles on AI use cases and exploration of those aspects, not policy issues. So he's from a technical side, technically, although he's a legal expert in AI and IP. And Ayush comes from a cybersecurity law side, but he's also the chair of a policy innovation committee of ISAIL. Very talented and very nice person. So let's go ahead. And Kailash, I think you can now present. You can show the screen, and please, you can go ahead. I'll just mute myself for now. You can give context on the guidelines, and then I think Ayush can add up.
Sure. So, hello everyone. We will be discussing today the computer related inventions. The government has released the draft and the last date of feedback is 15th of April. First, I will give you a quick background why, what are CRIs, why we are discussing it, and what's its important in patents. So, as we know, intellectual property right, we do have something like in the property which is in physical mode. If you work on something and you produce something, for example, you build your home, so you get right over it. Someone can't use your property without your permission. Someone, you can sell your property, there is a value in your property. In the same way, in IP2, when you use your mind, and in more economics term, you use your labor to produce something. So if you have produced something that is useful, definitely you should have a right over it. So just because the something you have produced and it's intangible, which doesn't have a physical form, that you should not have right over it, that can't be accepted, because there are inventions which are very useful, and there is the only difference between the your property which has physical nature and the other which is intangible. It's just the form, rest is everything is same. So from this concept, the intellectual property rights comes into existence. We do have patents, we do have copyrights, geographical indication, trademarks, designs, and protection for plant varieties as well. So we will start with patents. What are patents? We do have Patent Act 1970, and there are various provisions to, if you want to protect your property, that is your invention, you need to show to the government something. You have to pass a criteria to get those rights. So for, if you pass that criteria for 20 years, the property is yours and you can commercialize it, you can make money, whatever investment you have done, you can, you know, get it back through the various tools. Like you can sell your patent, you can commercialize it, you can give it to someone else, or you can share with someone else through the contracts, like licensing and all those tools. So under the patent tax, although the different sector have some variation in terms of eligibility, when you file the patent, ask for your rights or the ownership of the invention, there is little bit difference. For example, when the technology, your product or your invention belongs to a biological field, or your invention belong to a, you know, chemical field or a computer related, software related, there is little bit difference, but overall the eligibility is the same. So we will talk about the eligibility. So there are three main steps if we talk the main concept. One is the nobility. You should have to show that your invention is noble, or your product, your property is noble, or then you have to show that your property is noble. Just for a sec. Hmm. Okay, just leave it. So there is section, something called section 3. Under section 3, there are certain terms like a list of subjects which are not patentable. The title is what is not patentable under the patent act. So there is something called section 3K, which is related to the computer related inventions. So that specifically read as a mathematical or a business method or a computer program per se or algorithm are not patentable. So as you know, the patent acts came in 1970. That time the computer related invention were not that much developed, or the algorithm and your software was in the developing stages. So that time the policymaker didn't think its importance, but with the passage of the time, we realized that there might be technologies or the softwares or the computer related invention that may contribute substantially, having utility and the industrial application, but they still might not be patentable. So that created a problem. So to solve those problems, we just came to the computer related invention guidelines from the patent offices, which give us a way that how we can solve this problem or how we can approach this problem. So why CRIs? After 1970s, because of the increase in the computer capacities and the development in the computer related invention, there have been a more and more application from this area. So the eligibility is little bit different when we talk about the all these steps which we just discussed, when we compare it with the other sectors of patents, other sectors of technologies. So this is a data from the US patent office. So there they from 2015 to 2020, it's clearly visible that the AI related invention, the rejection rate is 45% as compared to the non AI invention, which is just 10%. So that shows the difference, that there is some problem with the already existing or approach as compared to the CRI and the AI related inventions. Even if you see the first graph in the left side, the rejection rate in evolutionary computation, natural language processing, and knowledge processing is much more than the, even in the CRI category is more. So all those, the first three factors, like it's related to the AI, although not completely. So rejection rate in AI is more. That's why we are discussing today that we might need something even more than CRI to the protection or to take care of this challenge. So why CRI? What we are going to discuss is there are four major main categories we are going to discuss. First two I will take care, and the last two of the subject will be taken care by Ayush. So here we will discuss our definition of technical effect in AI and machine learning, then demonstration of technical solution and the technical problem, then analysis of the guideline example. This guidelines example will be discussed by Ayush. Then patentability in algorithm, then condition under which the algorithm can be patentable in AI ML system. Here I would say that the all these first three areas will be discussed under one umbrella approach, which is a common approach for the patentability. They will cover everything. And for the algorithm, it will also be covered, except some area that I will specifically talk about algorithm where it is different. Otherwise, it will cover in the first three heads as well. So the first CRI guidelines came when we realized that there is a lot of rise in the computer related invention application, and we just have one word, that is 3K, like only one phrase that per se they are not eligible or they are not patentable. So to address this issue, because we are the one of the biggest market and software development of software services, software as a services SaaS in the world. Because of because of that, there have been a lot of application, there have been a lot of rejection, but in other country there is already developed, they have already made that leniency to make the computer related invention patentable. For example, in UK, in Europe, we call it computer related invention, there they call it computer invented invention, CII. So they have made this development way before than we have done. So first CRI came in 2015, then again 2016. We'll talk from 2016 because it is more related to next CRIs. In 2016, they produced a three-step test to make that how they are eligible. So this three-step test is like you have to properly identify the actual contribution, then denying the, you will be denied directly if it's just a mathematical business model or the algorithm. That is exactly what is given in the section 3K. And then third point is requirement of novel hardware. The requirement of novel hardware is the actual challenge here, because in almost all the computer related invention, it's very challenging to show your invention in a changes in the novel hardware. You can show from the comparing with the prior art that what changes you have done, how it is useful, and how it can solve a new problem. But to show it in changes in the hardware is tough. So because of that, there was a lot of objection from the industry, because the other countries, they have already make more lenient than the this CRI 2016 eligibility of three step test. One more additional thing was there in CRI 2016. There was 15 negative examples given. Negative example means the explanation, because in CRI there is need to be something more than the law or guidelines like the patent acts, patent or copyright acts, or the patent rules. We need something more than that in explanation actually. So there were 15 example or explanations which were negatively given. Negatively in the sense that they have explained which is not patentable, which CRIs are not patentable. Then CRI 2017 came. They have removed the three-step test. That's very good. They have removed the novel hardware requirements. But they have done one blunder here. They have removed the 15 negative examples as well. So it was like they have made two steps forward and one step again backward. It was criticized a lot. Now the criteria of the patentability is like it is quoted from the CRI guidelines. I will just read the main area: the technical nature involving the technical advancement as compared to the existing knowledge, or the or having economic significance, or both. It is at least the same what we have talked the first three criteria, that is the inventive step, new invention, and the utility or the industrial application. Utility and industrial application, we use same, both the terms for the industrial application. Utility is also belong to the same term. There is no difference between these two. Then before going to that, we will just take the some exact what is the criteria for invention. Like we talked about the three steps. So here we will elaborate a little bit more what is an invention, and then next we will talk about what is an inventive step, because these are most fundamental areas to understand in terms of patentability, whether it's CRI or the patent from the other sector as well. The criteria is same, except the some specific area that I would discuss. In the 2014, there is a judgment came by Justice Amit Bansal. So they have given something called the like seven stamba approach, like the seventh heads. So to check the invention, like you have filed an application, then how to check that whether it is an invention or not. So they have given these seven heads. These seven heads are actually nothing but the whole development from the previous last after 1970, whole those year. There is something told, there is some other criteria has been told. The judge has actually combined them together and make a single approach, or a which he called the single stamba approach. It is, I am discussing it here because this is given in the draft 2025 guidelines as well. So the first step is the understanding the claim of the invention, that the what are the claims are actually in an application. When, for example, I have made a new software, so I want to patent it, I have to go to the file an application. There is a whole procedure. I have to file a patent application in the patent office to explain everything, that how my invention work, what exactly it is, with the help of graphs and everything. It actually differ from industry to industry. I will discuss that later, how it differ. First, we will talk about the mainstream approach. I have to explain everything in the complete specification, that what was the prior art, what is the advancement I have done, what are its usefulness, what was the usefulness, something more than the what was already there in the prior art. Prior art is the previous knowledge, because when you can't make some invention out of nowhere. You have taken the inspiration from something which is already there, right? So you have to analyze the prior art. Prior art is, we call prior art is a actually term in the patents, which is like what is already there. For example, you have developed this so Microsoft has developed the Microsoft team, but Zoom was already there. Okay, Zoom might have patent, Microsoft might also have patent, might not be. I'm not sure. I'm just giving an example. So Microsoft have to show that what are the advancement you have done over Zoom. Here, prior art is Zoom. Then the determination of the explicit and implicit disclosure. Disclosure is actually explicit and implicit disclosure is you have to disclose everything about your invention. So explicit disclosure is what is exactly you have described there. Implicit is sometime it happen that you have described something, then you have made the claim. Claims are the your right, what you are asking to protect actually. Like for example, I'm just giving an example here. In the Microsoft team, you will ask that a lot of person can join together, or you can share your screen. So I want to protect the sharing screen because no one has done this before. I want to protect the uh, uh, I would say the conversion of my audio into the text, which is there if there is available here. So those are my claims. So sometimes it's happen that you can claim something more than that what you have explained if it's logical, if it makes sense. So from that term, we talk the implicit and explicit disclosure. Then assessment of the material differences while considering the entire scope of the claim. So material differences in the sense that to compare it with the prior art. Then verifying the novelty in light of the comprehensive scope and the specific combination of the claimed elements. So to verify the novelty, scope, and the specific combination of the claimed elements. Like now you have to read the whole the claim together. But claims are not like it's very rare that there will be one or two claims. Sometimes there is 10 claim, 15, 20, 30, even the 40 claims as well. If the invention is complex, specifically in the chemical field, there is a lot of there is a lot of claims. So last point is the documentation of the analysis, like all the 6 steps you have to analyze together and to determine the novelty. Then next is the inventive step. In the inventive step, when we read the definition of inventive step definition is given in the section 2JA, which says that there should be inventive step is defined as there should be an technical advancement or the utility, and it should not be obvious to the person skilled in the art. So either there is a technical advancement or either there is utility, and it should not be obvious to a person. Obvious is something like any one person, knowledgeable person can do that. There is no use of brain. That's called obvious. If there is obviousness, it is not patent, even if there is inventive step. So we have to comply with both the terms. Either there is, once we talk about the, let's say the inventions related to the CRI, then we will say there are an inventive step. There are two requirements. One is technical advancement. You have to show the technical advancement, like technical advancement over Zoom in the MS Team, just an example. And then it is not obvious to the person skilled in the art, like a person who is a software engineer. It is not obvious for him to make some changes and then to make the MS Team from the Zoom. It should not be obvious. There should be some use of brain. So that's obviousness. After passing these two main criteria, then it become inventive step. Then we can say that you have passed the inventive step. Then identifying the relevant common general knowledge. This general knowledge here talking about the prior art. Identifying the inventive concept of the claim in question. Identifying the relevant common general knowledge. Identifying the inventive concept of the claim in question. That means what you are claiming, what is the concept behind that in the complete specification written, which you have submitted in the application. Identify what, if any, differences exist between the matter cited. Then viewed without any knowledge of the alleged invention as claimed. So it's from the person skilled in the art. When we identify, we don't assess it from the knowledge of a general person, like a person from law field, or person from biology field, a person from the technical field. He will, the examiner at the patent office will examine from that point of view. Like suppose he's a person from software field, so he will examine okay, there is uh, there is Zoom, and then there is Zoom as a prior art or the already existing, which is called that the second point, general knowledge. And then there is MS Team. So what is the difference between the acknowledge if the engineer or a software engineer, a techie, in his knowledge, whether there is use of brain or it is obvious for him to do, anyone can do, he can do it easily. He can identify that yes, it can be done. Then it's not, it is obvious. Then it would not be patentable. If it, if he would accept that from his point of view, the examiner will analyze from his point of view. If it's not obvious for him, like the even the techie have to use his brain to come from Zoom features to the MS Team feature, then you have passed the inventive step and then it become eligible for patent. Then we will go through some important cases. The first case was Farid Alani versus Union of India. They have discussed the, because I will not go through the whole case because that would become irrelevant because every case has different specification. I will just stick to the exactly which is of our use. They have discussed that they should have technical effect and the technical contribution. They have told that the software novel software requirement is not necessary. So they have introduced this term technical effect and technical contribution. Then later two more cases came, Radon and controller of patent in design and the Microsoft technology cases came. They have reiterated the same thing that the novel software requirement may not be necessary because it is creating a problem. Then we came to there are actually 4 Microsoft cases. One is the first one. Then Microsoft 2, I will call it Microsoft 1, 2, 3, and 4. That will be easy for us to understand. So Microsoft 1 and 3 will be and was delivered by New Delhi High Court. Second and fourth was delivered by Madras High Court. So here in the Microsoft 2, the court has clearly, boldly criticized the CRI 2017, which they have done that they have removed the 15 example. They are actually called signpost. You will, when you will read the guidelines or the cases, you will read the signpost. Signposts are something they are guiding the patent office. Actually, they are guiding the courts, they are guiding the patent agents that whether it is been eligible or not. They will give it an easy way to understand how I have to submit my application to the patent office. Otherwise it will become tough for the person. Then in the Microsoft 2, I will exactly go through some quote some exact line because it is important, because they have been quoted throughout the all the cases that came after that. So this was actually a technology delegation of instant messaging session. So the patent office rejected the application because they says that there is no novel hardware criteria was not met. Even though the novel hardware criteria was been removed in CRI 2017, again the patent office was have that mindset of CRI 2016 and previous mindset. They were rejecting the application, but court clearly criticized that why you are going backward. There is a lot of development in this area and there is no technology where the algorithms are not used or the software are not used. This would hamper the technological development. So if we talk about what is the reasoning given by the court here is, what is the motive of the patent here, what is the motive of the intellectual property right. When see the patent act as a whole, section 66, there is a public interest that there should be you will be given the ownership for 20 years. That's a limited period. That too for because you have used your brain, you have used your labor, so you can use it any way that you want. You can commercialize it, you can make it money, but after 20 years your right ends because the public interest is also there. We have to take care of the right to scientific development of the public at large. So if you will be keep rejecting these application which are of very useful, having utility and the having capability to solve the real world problem, make everyone's life easy, still you will be rejecting this application. It will hamper the invention because people would not input money in the research and development because you are not, because they are not protectable. So because there will be no R&D, it will hamper the invention and it will hamper the public interest by because they are not getting the that development which we are expecting from the computer related invention, at least from this area. So this concept was introduced by court, and the court has told that we need some leniency in this area because the situation is not the same as 1970. So actually, the court has also explained that it was actually comment from the other side, 2017 to 2016 to 17, why this whole changes were done. So there was a similar situation when 2016 guidelines came. There is a lot of criticism from the industry. Then they changed, the patent office changed. Then came with the CRI 2017. It was the same situation. Abiodhan might be aware that the when in March 2024 they have related the AI related guidelines, MITI. Then first week they have released the guidelines. It was criticized a lot. Then next week they have changed, made substantial changes in the guidelines. Something similar was happened here. From 2016 to 17, a lot of changes were done. Some were good, but most the removal of that signpost, that was a negative thing. And the patent office still was having the previous mindset that was criticized by court. They have quoted the quote para 17, para 11 and 12 of the para 11 12 of the Farid Alani case, which was we have discussed previously. Then Microsoft 3 came. Microsoft 3 was on the same line. It was New Delhi High Court judgment. It was a judgment of Justice Pratibha M. Singh. What they have told about the inventive step, exactly the technical contribution, that it must contribute directly to a specific and the credible technical effect or a enhancement beyond mere the general computing process. So they have totally neglect the novel hardware, but they have told that if it is contributing directly toward the specific and the credible technical effect or the enhancement beyond mere the general computing process, it is patentable. It would not be barred under the section 3K of the Patent Act, or it would not fall under the criteria of per se phrase in the section 3K. So here I'm talking using these language because the every patent application has the different specification. So if I would talk from the point of view of the specification, we would miss a lot of things and it would confuse us. So that's why I'm just using the court language, exactly how they have approached the problem, and it's more easy to approach as well. Then after Microsoft 3, Microsoft 4 came. It came in the July 2024, like 6 or 8 or 7, 9 months from now. So this is very important even from the CRI, even for also from the point of view of AI and ML inventions as well. So what was happened in this case? The Microsoft filed an application at the patent office, giving an invention which talk about the and related to the application. So what they have done is the prior art was, if you want to open more than one application, you can't open more than one application without the having the surface command of the individual application. So for example, I want to open 2 or 3 application, I should have the independent surface command of the both the application. What they have done in their invention is that, what they have claimed is that our invention is enabling the opening or the access to the more than one application with the single surface command. We have integrated, we have done some changes, we have done some invention by we can open 5, 6 or 7 applications with the single surface command. So that was the invention. They have clearly told that it is purely software based invention and it is patentable. Please don't apply your brain of the 2016 guidelines or beyond that. Just like what I'm saying, it was not in the complete specification. It was rejected by the patent office on the ground of section 2JA, which is inventive step, and the ground of enablement ground. Enablement ground I will discuss later. It is also important, specifically from the point of view of AI and ML. So the court has criticized a lot the patent office decision because once it was rejected, the Microsoft came and appealed to the High Court. Why they came to the High Court? Because the appeal board was been dismissed into 2022. So now if an application is been rejected by the patent office, the appeal will directly come to the high courts of the respective. There are four centers where the application, like New Delhi High Court, Kolkata High Court, Mumbai, and the Chennai High Court. So Mumbai is Madras High Court. So the court has defined the per se, that the per se here is actually as such term. You have to interpret it like that. And court had in bold word told that the pure software based invention are allowed. You don't have to, you don't need to comply with the three-step test. You don't need to comply with the noble hardware requirement. From that point of view, it was a very bold, or the lenient, court has made it very lenient in case of the eligibility of the computer related inventions patentability. At para 36, court has specifically told that if your invention improve the functionality, provide the technical solution which solve a technical problem, it is patentable and allowed under the section 3K. It will not fall under the purview of the section 3K, which say that what is not patentable. Then, or in other word, court has told that if there is a computer program without technical advancement, it is not patentable. Otherwise, everything is eligible. Depending on the case to case basis, everything is eligible or everything is patentable. If it is just not a, it is a computer, if it is not a computer program showing no technical advancement or without technical advancement, otherwise it is patentable. Then we will come to the enablement requirement, because I told that it was rejected on two ground: section, inventive step and the enablement requirement. Enablement requirement is the, as I had told, like the what three step ground I have told: invention, in inventive step, and the industrial application. That is the, I would say, the major criteria. Apart from that, there are other criteria which vary on the sector to sector. For example, if a patent application is related to the biological field or the microbiology or the pharma field, for example, you have made a, let's say example from the COVID-19, you have made Covishield. You are the, I am the owner of the Covishield. I have made the invented the Covishield. If I go with my application that I want to patent Covishield, what I have to show? I can't show it on a document, because the, according to the guidelines, you have to comply with the guidelines of the patent office, and there is something called patent manual and the patent rule. You have to follow that. You have to write everything, prior art, what is the inventive step, and all those stuff. You have to show in the graph the technicality and everything. But in terms of the microbiology, you can't show that, right? So the requirement there is, you have to submit your sample is like what changes you have done in your RNA or DNA, whatever microbiology stuff, like at the DNA level you have done. You have to submit the sample to the patent office. That's a requirement. If you don't submit, it's not patentable, whether it will pass the three-step main eligibility or not. So in the same way, some other sector, there is some other requirement. For example, you have got a patent at in USA or the Australia or UK or anywhere in the other country, then you came here filing the uh, patent application from the same or the related field, something called the, there are patent related to each other as well, which is called the patent belonging to the same patent family. So if you're filing those patent, you have to provide all the information. You have that wherever you have filed the application, you got the application, you got rejected, why you got every information. So those are other requirement. In the same way, the enablement is also a requirement. So what is enablement? Section 10(4) of the Patent Act talk about the enablement requirement, that the, you have with your application, you have to show how your invention operates, how your invention will be used, or the method by which it is to be performed, or the or you have to provide the best performing method in the CS. CS means here is complete specification. Complete specification is the document which you submit to the patent office to ask for your right or to ask for your ownership or your patent. You have to show that thing. Why it become important here? From the AI or ML point of view, there are only a few things in the 2015 guidelines which are new as compared to the 2017 guidelines, okay, which are important for the AI. That I will discussing only those things because the rest are the same. So why it become important here? As we know in the invention related to the ML and AI, it is as compared to other CRIs, it is not easy to show how your invention work. Let's say if it belong to the pure from the AI field, the you are aware of the black box paradox. Even the, let's say for example, even the OpenAI doesn't know how their whole set of LLM works. Just giving an example, because the way it works, you can't describe it in a formula or like in chemical field or the other, even in the CRR or computer related invention apart from AI or machine learning related inventions. So there, this enablement requirement may become a barrier when the patent is specifically or entirely from the ML or the artificial intelligence field, right? Because in CRI 2025 guidelines at page 22, they talk about the best method of performance. When you are talking about the best method of performance, you can't just describe it. The patent application is a very rigorous. Everything will be checked by them. When we apply the application, it might be like 500, 600 pages. It might be possible. And then the examiner will check the application, that what are the new changes, what is the prior art and all those things. So you have to explain everything, otherwise it will be rejected. So to the applicant, the owner of the invention, he able to make his safe side or to make sure that he will get a patent, he have to describe everything. So under the best method of performance, you have to show that how it works. But in patent related to specifically from AI, entirely from AI or ML field, it will become tough for you as compared to the other CRI related inventions. The act require, it is also, I have taken from the CRI draft 2025 guidelines. The act require the application to specify what is the invention and how to perform it. So this might become a issue for the AI related invention. It might act as a barrier because it's tough, challenging for the applicant to show how it works. So one thing, Farid Alani, which was the first case, that has created a problem when we talk about the, not actually the problem, confusion. They have shown that we need to show the technical contribution and we need to show the technical effect. But they have told that whether it's the technical contribution or the technical effect, they have just told that it's technical, the invention must show the technical contribution or the technical effect. But we mention the or look into the other jurisdiction, I mean to say US and UK. Their view or the definition approach is different. Either it is technical contribution or the technical effect, because they are two different things. But in the Farid Alani or next two cases, they have used these terms interchangeably, so giving an apprehension like they are the same term. So that was the challenge or confusion that was created. But here from the Microsoft 3 and 4 cases, they have dumped the technical contribution term and they have specifically quoted the technical effect term. So this issue has also been cleared. Then there is one more judgment, Lava judgment, which is also important. They have uh, described more something, what is the computer program, like not something too different, but is the same line with the Microsoft 4 and the Microsoft 3 and Microsoft 1 2 as well. Then they have also cleared the Farid Alani confusion here, that it is the technical effect, not the contribution. Then the technical effect was also discussed in the ab initio case. Ab initio is 2024 judgment by I forgot the judge's name. It is this invention related to the uh, vacuum maintenance in the airplanes. For example, when a plane go to certain heights, because of the air pressure, you need to maintain the pressure inside the plane or outside the plane. So this technology was actually a huge device which work on that area to make that equilibrium between the pressures. So it was rejected. Then court has in their judgment defined the what is the technical effect. So it is not too different, but belong to the same, I would say, reiterating the same language at the previous judgments. Then algorithm, for algorithm the criteria is the same, but algorithm have a different definition which is important here. In Microsoft here I have mentioned that it is Microsoft case actually, because the algorithm doesn't define, is not defined in patent act, not in rules, not in the uh, what we call it, that patent manual. It is nowhere defined. So Microsoft case given a definition like they are set of rules or instructions that solve a problem, excuse me, through a sequence of steps or operations. Then again, BlackBerry case, they also given an definition almost on the same lines. Overall, our stand till now, or the current stand on algorithm, is that algorithm per se are not patentable. It's clear. You need to do something more or to show some technical effect with the algorithm, or a substantial contribution, then it become patentable, like the same thing which we have just previously discussed. Then there is something called secure system. Secure system is also defined in the CRI 2025. Why I am discussing it here? Because it is important from the point of view of AI. They are saying what is a secure system, then they given 3 bullet points, that something which is reasonably secure from unauthorized access or misuse, provide a reasonable level of reliability and correct operation. Here where the AI comes into picture. When we talk about the CRI, apart from AI and invention related to the AI or machine learning, there it might create a problem, because the reasonable level of reliability and correct operation is output. Reliability, we know that it is very challenging in AI to show the reliability. In CRI, to some extent, software patents, software invention you can show, but in pure something invention which is related to the AI field, you can't prove the reliability or the inexact term, because they are not reliable. You talk about the, just giving an example, any LLM take into example, are they reliable? Even the owners say that it is not reliable, because even we don't know that what would be the exact, when we put a prompt, what will the exact output. So in the advanced level of some invention which is more than LLM, same issue will come into picture, so that might create a problem. Then the
Uh,
last one.
Kailash,
Yeah,
just to add, I think
yeah,
this is going well. I think we are already past an hour. So what we can do
yeah.
is
So just
maybe
it's
if
the,
you, no, no, no.
yeah,
So let me
yeah,
just complete.
yeah, sure.
Within 10 minutes, you can, because I think I think I see that you're discussing some facets of the current issues and the
Yeah, yeah,
current guidelines as well. So
yeah, yeah.
if we now move to that, maybe within 10 minutes, I think that's my
Sure.
suggestion. But
Sure, sure. I'm just at the, just concluding in more than not. I will not take more than 5 minutes. So the last is the adhering to the generally accepted security procedure. There is no security procedure with respect to the AI. We only know the few. The only thing we know that there are few guidelines from the MITI which talk about the governance of the AI, but security procedure, they might be from the other sectors, but not from the AI and machine learning. So that might create a problem here. So that's it. Next two issue will be discussed by the Ayush, and Ayush can add on if he would like to talk the subject which I just mentioned. So over to you, Ayush.
Yeah. So thank you, Kailash. It was a very insightful PPT and a very engrossing one. So I want to touch back and go back to the starting of the stuff. CRI guidelines as per the 2025 guidelines, because as you people know, that Patent Act was in 1971, which is a very old act, and we did not have much inventions at that time. And later on in 2002 or 3, the Patent Act was amended, which actually enabled the understanding on
I think there is some
AI
like
and
issue
ML,
from your side. Uh,
not at that stage because
Ayush, actually, there is some internet disturbance from your side, I think.
one second. Uh, Yeah, am I audible now?
Yeah.
Yeah, now it's
Yeah.
audible.
So what I was saying was that if you know, like the Patent Act was earlier um, introduced in 1970. At that time, we did not have any such latest invention and any other in changes because we were just out of our independence, and it was just basically 20, 30 years or so. So we did not have that. But after the Patents Act 2002 or 2003, the amendment, we saw the inclusion of AI, computer programs, algorithms. Though we know AI has been there for many years, but it has come into physical existence and working concept in 2002 with the starting of OpenAI and all. But hardcore AI and its fundamentals were already aligned way back. So that's the understanding. So later on, after as per the amendment of Patent Act, the inclusion of all this, what are we discussing with regards to CRI guidelines came into picture, and over there we came across the computer program per se, the algorithm, the business program, the business method, the mathematical codes and etc., which were excluded by the courts because of the patentability. That's how we have come across the CRI guidance, and hence we are here to discuss about the same. So I would like to go into a little bit deep with my understanding on the technical aspects and what does exactly the CRI guidelines mean. Uh, we'll start with the technical effect in AI and ML. So with the inclusion of the CRI guidelines, we saw that the patents office they want to understand what is technical effect in AI and ML. So technical effect in AI ML would be basically when when the understanding or the concept is translated or transformed into a working model which tries to reduce the efficiency or increases the productivity of the uh, program or the product which is being patented or wants to be patented. That's when the patentability shall be given based only on the technical working aspect, not on the concept, not on the abstract idea, because we know patents cannot be working on an abstract idea. They won't be patentable because you need to follow the fundamental guidelines of Patent Act, which is novelty, innovative, and new models, and innovative. It should be a newly concept. It should not be used or discussed or developed in the prior stages. It won't count as a patent. Uh, even the Patents Act 2020-22 actually spoke about the timeline of the patent tax. It's basically 20 years, so there was nothing change in it except the introduction of technical AI effects in AI and ML. That was an understanding which needs more enhancement, because right now we do not have a proper framework on technical effect. We know we need to have a working model. We cannot just have uh, a basic concept, because if we have a working model when we are applying for a patent, it helps the patent examiners or the investigators to understand, okay, this is a working model, how this will benefit the industry or the workflow of an individual or a company. Based on those grounds and the fundamentals of Patent Act and the registration and acceptance, we'll move forward with the implementation, and we'll see how the guidelines come into effect with respect to technical aspects. Uh, Going down to the understanding, the judicial interpretations have been more so towards um aligning us with that we need to focus on technical effect rather than abstract or mere ideas. Various guidelines and various judgments have actually made us, given us a framework on how we have to deal with the understanding on the patentability in the new era. And as what Kailash said about 3K, Section 3K, with regards to the exclusion, which is basically the relevance, because we cannot, like I said, we cannot only use abstract ideas or any computer code or any such like that, because we need to have a working model. Without a working model, we cannot claim it to be a patent, or we cannot make it into a enforceability of any usage. So that's again on those points. Uh, then rightly said by Kailash on the 15 negative principles which were not included, the seven stumps, those are very vital towards the CRI guidelines. And prior art is something which is always disputed, because in terms of patent, when you are applying for a patent, we need to analyze whether the patent or the software or the program has been used ever, or it has been developed by somebody else. If it is, how it is different from the current patent which is being applied to the patents office, and how we can understand on the similarity and the differences between the two. That helps us to navigate the flow a more better as compared to what are we doing right now. So yeah, so now I'll focus on my points, which are the last two stages. Just give me 2 minutes. Just coming to it. Yeah. So my points would be conditions under which algorithms can be patented in AI and ML systems. So firstly, we were talking about technical aspect, the effect. For example, if you are working on a software which is basically towards helping X industry, we need to understand, okay, if we are making that product for an X industry, how that product can be helpful in the working of that industry without creating any barriers. Rather, it would help the scenarios. Based on those effects, we can actually call it as a technical technical know-how. We are implementing the software, we are implementing the process flow, hardware, necessary integrations or activities into that, so that we can actually transgrend it to into a different uh, byproduct in itself without alienating any of its patent fundamentals, which is the core concept which we need to look at from an point of view. Integration of hardware, if we know we are working on a very complex system and we require a hardware and we know the patent shall be a much better output with the help of hardware, then it's always good to use hardware, because we need to explicitly mention like what kind of hardware we are using, how that hardware can help us. For example, in CNN, camera sensor, traffic sign detection, these all aspects helps us, because if we are working on that model, we need to we need a hardware or we need a working product to bifurcate the code, or we bifurcate the algorithm in such a way that it gives us a better output. uh, Patentability of algorithms. So as per the section 3K, we know that algorithms and computer purchase are actually excluded from the definition of section 3K, which regards to the patentability exclusion. We need to see like how an algorithm can actually play an effect into a working model, rather than just being a mere understanding on a piece of paper. Because, for example, if we see Instagram, basically way back when Instagram was being developed, at that time, if we could have seen, they had created an algorithm based on reels. If that idea was on a paper and not executed, we would have called it as a uh, mere idea or something. But that algorithm for reels to work in real life, you need a working model. So if you see Instagram now with respect to the reels system, that's where the algorithm that actually worked into the upliftment and the more making the app more fluid and more engageable to the audience. That's when we can actually call algorithm in working format. Otherwise, it will not be used, because it's just on a mere, it's just a code or a source code or a computer code which is written. It's not a working model actually. And even with computer program per se, we cannot just work on the mathematical or the scientific or a business method. We need to allow that system to work on a working model. Without a working model, your patentability and all these things will not come into effect. And that's when we get to know about the patentability, whether okay, this algorithm and its understanding and its workflow can actually help in a betterment of a app or a industry. That's when it's more fluid for the patent investigators to understand and work upon it in a whole, rather than just being a mere idea. Because in our IP laws, mere ideas are paper. Piece of paper does not have any value as compared to a working model right now. Uh, yeah. So those about were the patent and condition and all. If I have to speak about the practical example, or we can call it patent. For example, we can call it as in Tesla, we have that uh, what you can say as the automatic steering wheel. So even in that, it's not actually a hardware kind of a thing. It's more on a software based, where the algorithms have actually been updated, enhanced to send signals to actually calculate the uh, mathematical, logical reasoning and integration in hardware. that's when we have all this uh, compilation into one frame, and that's how the automatic steering wheel or the automatic cars, the steering wheel comes into play. So if we see from a patent investigator's point of view, and we keep an eye on the section 3K, without just making it on paper, we can actually call that a product as a patent. And I'm sure that patent actually has been filed and it's already been seen in the cars of Tesla, uh, etc. So that's my understanding on the section 3K and the patentability and the hardware and the integration with the mere understanding of technical effect in AI and ML. Coming to uh, more parts on these. So yeah, for when we are patenting any AI or ML algorithm, we need to see the requirements, like what requirements go into picture. Firstly, it should be able to demonstrate a technical effect. It should show, okay, for example, I have made an algorithm. How does that algorithm helps me in my framework or in my productivity level? If that algorithm or a computer program or something is actually contributing 20 to 30% of the processing, and it reduces my work load and it increases my energy while working upon, we can call it as a technical effect, and it's able to integrate with systems, work upon it, maybe in guidelines based or formats. That's when we can actually call it as a secure patent. The biggest problems what I can see is that right now with respect to AI and ML, we don't have a proper framework to determine how it can be actually worked upon. So my suggestions based on the guidelines would be, firstly, if when the application is being sent for a working model with respect to AI or ML algorithms or this thing, the applier, the applicant, he has to specify the whole working model. If there is a requirement of uh, disclosure, he has to actually disclose every single data what he has been used, which helps the patent investigators and the examiners to understand, okay, if an algorithm is used, it's actually used in and transformed into a working model, or it's just sitting there on a paper. Based on those understanding, more based on more informational architecture of that system or of that product which is coming for patent, then it can actually give its view. Secondly, the examiners who will be examining all these, they have to have some skills and some additional working knowledge on all these things. We can see the CRI guidelines don't mention about the understanding that the examiners or the panel members, they have to have some requisite knowledge in the AI ML field. But what I feel is that we need more demos, we need more training sessions to make them aware on the changes of the AI and ML algorithm, because what we see, this is not a 2 3 months or a 2 3 years concept. It keeps on evolving. We cannot keep the knowledge stagnant. Okay, for example, if I understood this on AI ML, I know how AI ML works, how algorithm works. Okay, it's fine, it's well and good. But at the current speed we are having changes in the AI ML algorithms, the models, with the inclusion of Gen AI and all these things, I believe the examiners, they need to have more holistic view, more deep knowledge on these things, so that it can actually help us in identifying which of the patents are more actually useful, and every single thing can come into a one bucket. It can actually streamline the flow. Also, with the respect to the disclosures, the guideline should be, my feedback would be that uh, when we are applying, we should actually show a working prototype or a MVP to the patent examiner so that they understand, okay, this is the thing. They should disclose the entire workflow from sources they have taken, how they've used that source of knowledge, research, technical aspect, technical effect into that product, so that the chances of rejections are lesser, and the timeline is also reduced because the investigator does not have to go back and forth in making its reports, testing the same thing in a different format to see, okay, does this qualify as a patentable computer program, or it's a working prototype or something of that sort. It actually helps, like, we can, what Kailash showed us over the PPT was the rejection rates of the patent office in US. If we follow these guidelines, I'm 100% sure, and if the feedbacks have been implemented, I'm 100% sure that the rejection rate of all these computer related inventions can be reduced to a threshold, and we can have a more growing environment. Plus, we need to keep on advancing, and we need to amend our computer relation inventions, because what we have right now in terms of computer related inventions, we may not have it in the next 1 hour, 1 year or so. It's because of the rapid growing of the industry. We need to work in accordance with the trends and conditions. So this is my understanding on the CRI guidelines, and my understanding on the feedback what I would like um, over here being discussed, to reach out to the patent office, the Indian patent office, to um, as a part of our joint session. So yeah, that's all from my side. Abhivardhan, if you would like to say something. Abhivardhan, are you there?
I guess not.
Okay.
Let me try to call him.
Yeah.
So, you have rightly said the context of why it is important to consider the inventions specifically related to the AI, ML under the computer related invention, because the it's been a constant development stage. This whole sector is under constant development stage. Even just take an example, just 4 or 3 years ago, we doesn't have any understanding, or there was no LLM, there was no chat gpt, there was no open AI, there was no Gemini, there was no DeepSeek. But then just in last 3 years, just see how much development have been done. So if the patent office would get the same attitude to take care of this problem, it's like last CRI guidelines they have released in 2017, and then now 2025. There have been like literally 8 years. And just imagine if the next CRI guidelines would be released in 8 years from now, that's like 2033. The We would have missed the whole revolution of AI, man. That's the like I think very critical issue to be addressed. anyone would like to ask any question or to give any inputs with respect to the CRI guidelines or whatever we have discussed? You're welcome. So some other points I would like to discuss, like in 2025 guidelines, there is like in the 2016, they have introduced 15 examples or the signposts, posts, what we can say. But on the other hand, in 2025 draft guidelines, there are 10 positive signposts and posts and 10 negative signposts posts are given. So I think that's a good thing to go forward, because that would at least guide the applicant, that would guide the patent office, that would even guide the judges to interpret or give it more clarity exactly what should be patentable, what is not patentable, and that would help the applicant to file a better application to get the patent, or to avoid all the confusions if their application fall under the those 10 negative posts, then the applicant might change it to avoid those points or those specific uh, claims that make them fall under those 10 negative examples, so that it can be avoided and he will get the patent. So that's a good thing. Apart from that, there is one more thing which is very important, I think. Uh, Yet in the guidelines, draft guidelines, they have discussed the technical effect, technical advancement. They have given some specific specific examples that what could be the technical advancement, but there is no definition. What they have done is they have taken the reference from the courts wherever this technical advancement and uh, technical advancement is being defined. They have taken the reference and put in the 2025 CRI guidelines. These are not uh, these are not your definition. These are definition of the courts, and that's what might create a problem for the judges, because what do the judges do if suppose some application would come to court? Suppose the application is being filed and then it was been rejected, it comes to the court. What would the court do? They do interpret the law. Here what would they interpret? They won't interpret the already what they have been said, what they have been interpreted. The CRI guidelines quotes the definition of the technical advancement or technical effect from the judgment itself. I think that's not a appropriate way to address the, even if the patent office don't like to provide a specific definition, it might take some other approaches apart from the giving the definition of the patent office. I think that may help to tackle this problem way better than what they have done present. So Bogdan's question is, will the Trump tariff change the guidelines? Probably not, because that's what my understanding is, because most of the Indian startup from this field, like software as a services, is services, not the something goods which we talk in import and export. So I don't think that would impact much, but it's a caution for us. Why? Because when we talk about the other countries, they have a lot of other tools apart from patent. For example, in US, there is something called the design patent, and then in a lot of countries there are utility patents. If you are not, your product is, your invention is not eligible for patent, it can be registered under utility patents. But then in India, if it will miss the criteria under the patents, then you are just gone. There is no protection to your patents. I think that might create a huge problem. So if anyone would like to ask any question, you may ask. Ayush, would you like to add on?
Um, like it's a very tricky situation, like with what Trump's have Trump has done with regards to the tariffs. Um, it would affect in terms of the hardware import and export, but with respect to software part, it may not be. But we never know like how it negatively affects or how it will affect the industry. But maybe they may have some consequences on the industry as well, which we may see in the possible time. But what Kailash says is like it's like 50-50. It may be true, it may not be true. Let
Yeah.
We need to see on like how the whole understanding plays out as of now, and maybe we'll get to know about in few days like what else maybe the Trump administration wants to do on these parts. If they levy, then it can be a significant backlash if it's on a goods on or maybe parts or imports of computer products or chipsets or semiconductor, then all that can have some repercussions. But right now it's like too early to comment on it. The industry and the markets are still reacting towards it. Maybe in couple of days we'll understand what exactly would go down when the Indian government responds on the said tariffs. And yeah, that's my take on it.
Yeah, exactly. If not directly, then indirectly there might be impact on the guidelines as well as the maybe the whole sector, but we can't, predict right now. It's just the beginning. There is a lot to happen, I guess, because India haven't responded yet what approach it would like to take, whether it would put reciprocal tariff like China, Canada, and some other countries, or it may just take a wide step to negotiate.
Yeah, so yesterday there was a statement, or day before yesterday, there was a statement published uh, on Press and Information Bureau.
Yeah,
Uh, Unlike other countries like Vietnam, which is literally saying for zero tariffs, the government of India is open for a proactive negotiation.
yeah, exactly. Because
That's good, but yeah,
yeah, yeah, reciprocal tariff doesn't make sense for India because we would be at
yeah,
loss because we are exporting a lot of, we have a huge export to US. So reciprocal tariff is not a wise step. Instead of negotiating or enter into an agreement, at least even for a temporary period until and unless this whole issue will be resolved. Because
yeah,
I think China and some other country has already been challenged these old tariff new tariff rules to WTO. So that's also important because a lot of country will be one side there.
yeah, yeah.
So would
Uh,
you like to add on something on the CRI draft guidelines or?
so I think what can be done is that I believe sometimes I think we did well with this session in terms of exploring the jurisprudence and the policy understanding around. But I think since we have 10 days, I think uh, as an outcome of the session, we will of course take this recording into consideration and in cooperation with ISAIL members and advisory council experts, let's come up with a documentation of this.
Sure,
I think
sure.
we need more inputs to add on, and I think that's the way it is. And yeah, we'll send it to Bogdan as well, since he's the vice president of the advisory council. And yes, that's how we will word for now.
Sure. So shall we conclude? Because there are no
Yeah,
questions.
yeah. Yeah, I think patents. It's actually interesting that people are obsessed about DPDPA, but they were less interested about patents, which again affects us as the market. Like last year, Amazon got patent for natural language processing, which is a serious thing. They applied in 2020 in the USPTO, but lack of awareness. But anyways, I think there will be more feedback points which will be coming up after the session. So that's the thing. Anyways, I'd ask you to stay, and I'd like to discuss with Ayush a little bit. So just wait for a minute once we end the recording.